So in terms of your expertise, in terms of, most people, both spouses work, both have their own careers, what would be your advice to maybe a young couple getting married? What would be your option as your preferred contract?
It's difficult to say because it's very personal. I think it also it depends on the obviously it has very financial implications. I would say in the past that if both parties were well established, let's just say it was a second marriage for both parties, or one of the parties, maybe they had previously been married and now they were getting married a second time, they would probably opt for out of community without an accrual because you can have a very established businesswoman, well-established businessman. They're both running their own entities, and yes, and they don't really want any sort of commingling, and they're quite happy with that sort of situation, and it makes it clean and neat. If they get divorced, that would probably be a good way to go. Now, because the law has changed, depending on, again, like I said, any contributions that a party may wish to rely on as, in terms of enforcing a claim against the other party, changes the aspects of it. I think that probably the most fair system is, and most common system is getting married out of community property with the accrual, because you have your separate estates that are dealt with separately prior to your marriage, and whatever whatever that growth is during the marriage, which is a union, marriage is a union, I think that is a fair system. Because like I said, it is the party who has a lesser growth has a claim for half of the difference of that growth. Okay. So I think that is a fair system. I mean, if you look at a marriage in community of property, if your spouse perhaps has huge liabilities and you now are affected by those liabilities, I suppose one could argue that is unfair. Obviously you've chosen to marry that way, but I suppose it could go both ways. I mean, it is a marriage in community of property. I think that you're aware of the risks, or should be, and ultimately that's one of the reasons that, or let me say, why I'm saying risks is because if a party, for example, is sequestrated, like I said, your insolvent spouse, that estate, will affect your estate because it's obviously a joint estate, so it's dealt with jointly, and then you would be affected by default. And that's why I think it's so important for parties to consult with legal practitioners, especially with regard to concluding antenuptial contracts. Because on divorce, when the parties are going through a tough time and are considering a divorce, that is the first document that they're going to
request.
The attorney will request, and whatever decisions you make and what you decide to exclude in that contract, because there are certain exclusions that can be set out in the antenuptial contract, which can be applicable to the marriage. And I think that a lot of those things need to be discussed, and certain of the parties, we do find that when they attend their consultations, haven't necessarily had a discussion as to what matrimonial property regime they are going to apply to their marriage. Many of them only learn about the different regimes at the attorney's office, and I think it's very important that parties sit down and they discuss.
Have an honest conversation.
Yes, because it has huge financial implications for both parties, and like I said, it affects how you enter into contracts, and ultimately any dissolution of that marriage, and how the assets or liabilities are going to be dealt with.
And also for us, you know, it's one of the required documents when we're busy completing an offer to purchase or we're signing a mandate. One of the FICA documents we ask for a marriage contract. So it's very important that the clients do their due diligence prior to entering in, you know, with any agreements, especially as a young couple that maybe hasn't got the life experience in terms of, you know, marriages and the implications thereof.